Hello, this is a presentation by Family First Legal Mediation and Collaborative Law Firm. This is a quick tip on how to use objections in court. This is for educational purposes only and not intended as legal advice or as a legal consultation. What is an objection? Objections are a formal way of letting the court know that something that a party or witness is saying or trying to present to the court should be rejected or excluded. This is how you prevent a witness from saying something that might be disfavorable to you but isn't allowable by law. Or this is how you prevent the other party from presenting documentary or other types of evidence which might be unfavorable to you or which might prejudice the court against you. And there are legal ways in which you may object to these different types of evidence that will be presented by the other party or by other witnesses. These objections allow for you to exclude certain evidence legally. Even if the evidence is valid or true, the evidence may be excluded. You should look at Maryland Rules of Evidence in Title V. To raise an objection in court, you only need to say the word objection after a question has been presented or after a piece of evidence has been introduced to the court, or a party is attempting to introduce a piece of evidence to court that is objectionable. You or your attorney will object to that piece of evidence or to the question that's being asked. Objections must be supported by a legal reason. So looking to the Maryland Rules of Evidence, you must find a reason for objecting to a piece of evidence. And then if that legal reasoning is found by the court to be true, the court will agree with you and not allow that evidence in. We'll get more in detail on that as we move forward. What is the importance of an objection? Objections prevent evidence from being presented. So, even if evidence is true, as I stated earlier, it may not be allowed in if there's a legal rule that disallows that evidence. So you will want to become very familiar with the legal rules as to what is allowed and what is not allowable. And sometimes even if evidence is allowable, by objecting, you can prove that evidence, though allowable, is not in a format that the court can receive it. So again, that will be you making sure that you or your attorney understands the rules of evidence and what formats are allowable in the court. For instance, if you're trying to present a document and that document is not authenticated, then that document may not be presented to the court, or it may be presented to the court but only for a limited purpose. The other reason, or the other important reason for an objection, is that even if the court doesn't agree with you and allow your objection, the court preserves your right upon appeal. So if that judge was wrong in not allowing your objection, then when you appeal, because you've objected to it, the appeals court now has something they can look to and determine if the court was wrong or right in allowing or not allowing your objection. If you fail to object, then you lose the right to appeal on any issue that you feel the judge made a bad decision about, or that the court made a bad decision about. So this is very important that you use your objections in court, even if the court doesn't allow them at that moment. Examples of objections you might use. So this might be a big question for you. What types of things can I say that are will legally allow me to prevent evidence from being shown to the court or given to the court? Now, these are two of the most used objections in family law: hearsay and relevance. Hearsay basically means that it's something that the party or the witness who's testifying currently has overheard, or someone has told them, but that person is not testifying currently in court and will not testify in court. And even if that person's testifying in court, the witness that is currently testifying can't testify to something that's said by a non-party. So the only thing a witness can testify to is something that's said by a party, like the plaintiff or the defendant in the case. Otherwise, if they're testifying, they can only testify to something they themselves have said. Anytime someone is trying to testify about something they were told by a non-party, you can object and tell the court that this is hearsay. This party does not have direct information. They are using secondhand knowledge that didn't come from a party to try to present evidence to the court. In this case, the court is likely to allow your objection unless a hearsay exception exist. There are exceptions to this rule where the court will allow hearsay, but there is very limited use of those exceptions, or very limited exceptions. So I would advise that you use this if you hear a party testifying to something that someone else said and that person's not in the courtroom or is not a party to the case, not the plaintiff, not the defendant. Another example of an objection that you will hear often in family law cases is relevance. You will object and you'll say this is irrelevant or it lacks relevance, meaning that if you look at this picture, someone could say, well, I went to the house on one occasion and the sink was filled with dishes and it looked really messy. And you're trying to prove that the person should or should not be able to get a divorce based on the grounds of cruelty. Having dishes in the sink isn't necessarily relevant to that issue. And so you can claim that you can object and state that it is irrelevant, and the court will have to decide whether having dirty dishes has anything to do with the abuse or the cruelty that may have happened that led to the divorce. Now, the court could determine that it's relevant in that if one of you all, either the plaintiff or the defendant, is testifying that on one occasion the dishes were dirty and that was the reason why the abuse occurred, then this, of course, testimony that the dishes were dirty on that day would be relevant. However, unless that is the case, or unless there's a real reason for why the court would look at the dishes being dirty, the court's going to find this irrelevant and stop any line of questioning that has to do with these dirty dishes. There are other objections that you can do, and there's other exceptions to even those objections that would be allowed. So it is important, again, that you know the rules, or that you have a legal professional on your side who can help you understand the rules and who will apply the rules for you in court. Court responses to objections. Courts can make one of two rulings. Generally, they're going to either overrule the objection or they're going to sustain the objection. If the court overrules the objection, the court does not agree with the objection and they allow the evidence to go forward. This means that if you're being asked a question and your attorney has objected, or you've objected to the question, and the court has considered the objection and the grounds for the reason you've asked for the objection, and the court still overrules it, that means you have to answer the question. That means you have to go forward with the question. The other option is the court might sustain an objection. When the court sustains an objection, the court agrees with the objection and the evidence is not permitted. So if you're testifying at the moment when an objection comes up, or when you offer an objection and the court says sustained, that means stop talking. You don't need to answer this question. The party asking the question must move on to a different question. Overruled and sustained also applies to documentary, digital, and other types of evidence. So if a party is seeking to introduce evidence, a documentary piece of evidence, or any type of tangible evidence to the court, and an objection is raised, the court will either overrule, meaning that document, that piece of evidence can be used, or the court will sustain it, meaning that document or piece of evidence cannot be used, and the court rejects that evidence. Whether the court overrules or sustains, whenever you hear an objection or whenever you make an objection, you should go slow. Slow down, listen to the proceedings, make sure you understand what's going on, particularly if you're represented by legal counsel. If your counsel is objecting to something, then you might want to think about the question and why might your attorney object to the question? Because in their objection, it might be that it's something that they don't want you to say, or something that they feel like you could respond to negatively, or it could be that they really feel like there's a legitimate reason for this evidence not to be presented, or this question not to be asked. But whatever the reason is, you want to think about it before you answer. So go slow. You'll still have to answer if the court overrules, but take a moment. Take a drink of water if you have water with you on the stand. Take a breath. Take a beat, and then answer. If it's sustained, go slow to make sure you remember that sustained means stop. I do not have to answer. So many times on the stand, after I've offered an objection, I will have a client who wants to answer the question because they think they have the right answer, and they didn't understand or didn't remember that the word sustained means stop. Even though that's something that's generally discussed between attorney and clients, that anytime you hear a sustained stop, it's really hard to remember these things when you're on the stand. So try to remember this stop sign. Whenever you think of sustain, think of the other S word that goes with it. Stop. I can't talk. I can't keep going. Overrule, think of the green light. Go. I've got to answer. But also think of the caution sign. I got to take it slow even though I have to answer because someone has objected. I need to think about how I answer this. This has been a quick tip on the use of objections in court, presented by Family First Legal Mediation and Collaborative Law Firm. This has been for educational purposes only and is not intended as legal advice. If you would like more information about this topic or you would like a consultation with us, please reach out to us on the web at www.fflmd.com or on social media at Family First Legal. Thank you.